Be ready. 5 seconds. Start. Learned counsel for the petitioner contended that impugned order of allowing the election petition of respondent number 4 was based on three grounds. The first main ground was that pro forma 4 relating to said election was not available. His contention is that said document relating to Form 4 was not available because it was present with sealed ballot papers and was not called for perusal. His submission was that second ground of passing impugned order was the alleged arithmetical error in counting of voters in this regard. He has submitted that although there appears arithmetical error of one count in counting of votes, but this will not affect the result because in Form 4 and Form 6 relating to said elections, the total number of valid and invalid votes were specifically mentioned. Since Form 4 is prepared on the basis of Form 6 and Form 7, therefore this arithmetical error can be rectified by calculation, and in fact no error was committed when result of said election was declared. His further submission is that in spite of filing of written statement, the prescribed authority had found it technically erroneous and had not accepted its pleadings, although there was no error in said written statement, which is in accordance with law and procedure, and such pleading should not be discarded at the time of judgment. On the basis of these contentions, learned counsel for the petitioner prayed for quashing of the impugned order of recounting of ballot papers. These submissions were refuted by Shri R. P. Tomar, Senior Counsel for Respondent number 4, who submitted that written statement of the petitioner was not discarded by the prescribed authority. On the other hand, it was considered. He further submitted that impugned order is passed after appreciating the facts and evidences and after application of judicial mind, in which all relevant points including arithmetical error was also considered. His submission was that in this particular matter, admittedly, there was arithmetical error of one vote, and the difference of votes of petitioner and of respondent number 4 was also only one vote. Therefore, in interest of justice, recounting should be done, and accordingly correct order was passed by prescribed authority. His further submission is that there has been specific report of returning officer that Form 4 relating to ballot counting was not filed in office, and in absence of such important document, declaration of result of election was erroneous. So far as point relating to alleged discarding of written statement is concerned, it is unacceptable from perusal of the impugned order. In this case, issues are framed in any case on the basis of written statement. In the impugned order, the details of contents of written statement were mentioned by prescribed authority, and it is also mentioned that on the basis of petition and written statement of respondent number 4, 7 issues were framed. Thereafter, learned prescribed authority had discussed the evidences available before it and decided all the issues framed before passing the impugned order. Thus, it is found that written statement of petitioner was not discarded by prescribed authority who had admitted it, considered its pleadings, framed issues, and accordingly passed its judgment. So far as the point of arithmetical error in counting is concerned, it is admitted fact that in calculating total ballot papers, difference of one vote was noted. The correct number of votes in all the polling booths is noted after compilation of ballot papers in Form Schedule 4. Although there has been submission of the petitioner that said schedule Form 4 was sealed with original ballot papers, but at the time of hearing this point was not brought before the prescribed authority, and there was specific evidence in form of question answer from district supply officer was placed, in which it was mentioned that returning officer had not deposited the schedule form 4 relating to counting of ballots.